Hey guys, CJ here. I want to talk about some issues that we're having down in Leon Valley that have just come to light after an open records request where we got some records from the city, specifically some emails that Joe Salvaggio has been sending out to his officers and actually shows probably why we're having issues down there in Leon Valley and why we're probably going to continue to have issues in Leon Valley. But while most of the issues down there are related to the First Amendment, there are some Second Amendment ramifications that have come to light that I truly want to highlight here because this not only affects us in the gun community, but also affects us in the First Amendment filming community, the right to film. And so I want to start with some emails here that we've gotten from an open records request. And what the emails are going to show is that Leon Valley is actively, the chief of police there is actively engaged in undermining the Second Amendment rights of citizens, both within Leon Valley and really anywhere. And so let me see, this is the first time I've done this, so I'm going to see if I can figure this thing out here. I want to show you these emails. Here's the first email. Not this one here. So this is an email that Joe Salvaggio sent out on June 5th, 2018, about 7 months ago, to his officers. And this is about the requirement to display a license to carry permit. Now, some of what he says in here is accurate, but a lot of it is not accurate. For example, he starts out, please be reminded that an officer does have the right to ask for identification, that's supposed to be of someone who is carrying a handgun, concealed or openly. Yes, Chief Salvaggio is correct here. Officers do have a right to ask. That's the key word, ask. If they're not doing anything wrong other than carrying a handgun, they can ask, but we are under no obligation to provide. And then he explains what open carry kind of means. So who cares about that? But then he goes on to say this. If the individual refuses to show you a license to carry, it is a violation of the following Texas Government Code. And he talks about Government Code 411-205 here, the requirement to display a license. If a license holder is carrying a handgun on or about the license holder's person, when a magistrate or peace officer demands that the license holder display identification, the license holder shall display both the driver's license and the license holder's handgun license. Now, there's no penalty if you don't do this, all right? This is in the law. It says that this is what we're supposed to do. But there's a key word here between what Salvaggio is saying, and he's conflating two words here. If you notice up here, he says ask. Has a right to ask for. The government code says if a peace officer demands that a license holder display identification, okay? These are two completely different words. A demand means that they have authority to compel you to do something, that they have authority to make a demand of you, not to ask you, which you have a right to ignore. If someone asks you to do something, you can oblige or not oblige. But if they demand, the assumption is you have no choice, that supposedly they have the authority to compel you to do something. So 411-205 says, I'm required to display a license if a peace officer demands that I display, not my license, that I display identification. So this doesn't say anywhere that says I'm supposed to show you a license to carry. It says if you demand identification. Well, when does a peace officer allowed to demand identification? I'm going to go through this email a little bit later, but what you'll notice is he talks about 411-205, 411-207, and 411-206, but what he's missing is 3802, because he comes down here and he says, when an individual refuses to provide you with a license, you have no choice but to believe they are unlawfully carrying a weapon in violation of state law. There are several issues with this. I wrote about this several years ago on my blog, A Soldier's Perspective. It's called An Open Letter to Texas Leos, and I break this down. I do talk about government code, and by the way, let me go back to that. The chief here doesn't even know his laws. He says Texas local government code. This is not local government code. Section 411.205 is in the government code. All right, so he doesn't even know what laws he's enforcing. I do. It's the government code, 411.205. And I explain all that here. Now remember, there's that word demands that the license holder display identification. Well, when is it a penalty? When am I required to provide identification to a peace officer? That's when you get to Penal Code Section 38.02. A person commits an offense if he refuses to give identification, essentially, that's what name, address, and date of birth is, to a peace officer who has lawfully arrested the person. Lawfully arrested the person. So how do you arrest somebody? How does that happen? You arrest somebody when they have committed a crime, right? So there's articulable suspicion. And I put this here, it says Leos may not demand to see identification unless the person is under arrest. As peace officers are aware, an arrest requires probable cause. In order to have probable cause, there must be articulable facts that a crime is, was, or will be committed. So that's that section. Now, what he also says here is that you have no choice but to believe they are unlawfully carrying a weapon if they fail to provide you with a license. Is that true? Well, I've got some case law in this blog post that I wrote back in 2014, I think it was. Do I have a date on this? I think it was 2014 or so. I don't have a date. That's weird. Don't have a date on this, but let's go through this anyway. United States v. DeBerry. In United States v. DeBerry, the court found that, now this is an Illinois case, right? But it's talking about Texas where Texas is mentioned because in Texas at the time, concealed carry was legal in Texas, but it was not legal in Illinois. But they say even if this were Texas rather than Illinois, and concealed carry was lawful, like it was in Texas, except for felons and other classes, the police would not have been able to accost DeBerry and ask him if he was carrying a gun. Why? Because if it was legal in Illinois, like it's legal in Texas, now this is the state using Texas as an example, or this is the court, I'm sorry, using Texas as an example. It would be essential that the officers have a reasonable belief and not a mere hunch that he was carrying a gun if he was violating the law. So they have to have a reasonable belief that, not just a hunch, that you are carrying a gun in violation of the law. In violation of the law. Now you go down to here, United States v. Nathaniel Black. This is a reiteration of Terry versus Ohio that says a Terry stop must be supported by at least a reasonable and articulable suspicion that the person is engaged in criminal activity. Then it says, it goes on, lawful possession and display of a firearm fails to support the conclusion that officers Astro had reasonable suspicion to detain Black. Now, if that weren't enough to say that what Salvaggio is saying here, that when an individual refuses to provide you a license, you have no choice but to believe they're unlawfully carrying the weapon in violation of state law, well, the court directly already responded to that. Where a state permits individuals to openly carry firearms, the exercise of this right without more, in other words, without probable cause, cannot justify an investigatory detention. Therefore, you cannot demand to see a license. Shall we go on here? Brown v. Texas, to detain an appellant, require him to identify himself, violates the Fourth Amendment because they lacked reasonable suspicion that he was engaged in or had engaged in criminal conduct. The chief of police here is wrong. Absolutely 100% wrong. You must believe that the person is innocent, not guilty first. The default cannot be that someone is a felon in possession of a firearm. Oh, by the way, the court actually said that. So that's what the court's saying. Absent articulable facts, a person is carrying illegally. You have to assume they're carrying legally. You cannot default to a person illegally in possession of a firearm. All right? That's the case. That is right there, spelled out in black and white. Now let's go back to this email. Oh, excuse me. Now I'm going to have to close that out, I bet. I'm learning this camera thing. So Salvaggio goes on. Okay, so what if they tell you that, they're not going to show you their license? Well, then you have to assume that they're illegal. And once you assume that they're breaking the law, boom, now you have magically you have probable cause. And this says you have the authority to disarm. Wait a second. You should immediately detain the individual for suspicion of violating 4602, which is unlawful carry, handcuff them for your safety and theirs, and disarm them. That's not what the law says, because he sits there and he actually quotes 411-207. So what is the authority of a peace officer to disarm? A peace officer who is acting in the lawful discharge of the officer's official duties may disarm a license holder at any time when? Well, when the officer reasonably believes it is necessary for the protection of the license holder, the officer, or another individual. Reasonably believes it is necessary for the protection of the license holder, officer, or another individual. The fact that you have a gun is not a reasonable belief that someone is a danger. They have to be providing you with clues and hints. So you can't just, as he says, oh, if they refuse to show your license, boom, cuff them. In other words, arrest them. Once you are placed in handcuffs, you are placed under arrest because you do not have a reasonable belief that you are free to go. So if they don't show you a license, arrest them or handcuff them, as he says, for your safety and theirs. Notice how he tries to use that word, for your safety and theirs, because it says down here, if you reasonably believe it is necessary for protection of license holder, officer, or other individual. But there's a word there that he doesn't have up there. Reasonable belief. And then disarm them under those circumstances. Of course, afterwards, you have to return it once you realize that you've been a thug and you haven't done anything wrong. Now, he might think that this is okay. The law says that we didn't get one of the other things that they have officers have been saying is, because the Houston Police Department website even still says this, that you must have a license to carry. Therefore, if you're shown with a firearm, because 4602 says it's illegal to carry a firearm unless you have a license, well, then it can be assumed that you're breaking the law until you prove otherwise. That's not how that works. And a lot of law enforcement agencies will divert back to, let me turn this off real quick. Another law enforcement officers will divert back to the fact that the Huffines Amendment did not pass. And the Huffines Amendment would have specifically told law enforcement that you cannot, in any way, shape, or form, stop and ID people just because they're open carrying. And so we were trying to actually codify that in the law, but the amendment failed. Now, the amendment failed, but that doesn't mean that just because the amendment failed, that law enforcement can stop and ID you. The legislature actually covered this because there was a big debate over the Huffines Amendment when open carry was passed. And the legislature themselves said, no, that's not the case. And you don't have to believe me. Let's go back to what did the legislature say? This is the House Journal, okay? This is the House Journal on the Dutton Amendment. This is House Resolution 3384, all right? They are discussing HB 910, and that's the open carry bill from 2015. This is the Huffines Amendment, a resolution right here. So they asked that these comments be reduced to writing. So Representative Dutton, by the way, a Democrat, he says, I've been a little afraid about this because, not because of you, not because of this bill, not because of the response of the people in here, but the response of law enforcement. And he says, I've also been disappointed in some of the comments that have made me very wary that they aren't going to follow the Constitution. This is Representative Phillips. He responded, you know what, Dutton, I agree with you. I'm a little concerned based off what law enforcement has said that they are not going to follow the Constitution. Dutton says, well, because he says, not all of them, but some of them. And Dutton responds, some of them are quite frightening because of their objection to this amendment, which this amendment, all it would have done was prevented law enforcement from harassing open carriers, which is exactly what Salvaggio is trying to do. That's exactly what his email here is doing, is about harassing open carriers, demanding identification, the requirement to display identification. That's what Salvaggio wants to do. And the legislature was concerned about that. So Dutton continues, some of them are quite frightening because their objection to this amendment, which I think you agree is already the law, which they say they're afraid of, which doesn't make any sense to me. If they intend to apply the law equally, that's what I'm disturbed about. But let me ask you a question, Mr. Phillips, and Mr. Phillips was carrying the HB 910. If a person is exercising their right to lawfully carry a weapon openly, and the police walk up to them and say, do you have a license? Does the person have to respond at all? Phillips says, I don't believe so under the Constitution. Right. Dutton continues. So if the police officer asks to see your license, does the person have to respond? Now, here's where it gets specific, because Phillips is like, oh, well, hang on, because he is using the word asks up here. If they have stopped them for a lawful reason. Yes. I should have made that. I should have said that a little more specifically. I appreciate you've laid that predicate for me. So here's the question. I'm standing on the corner. I'm wearing a weapon openly. The police drive up. I'm not doing anything else illegal. That's the implication there. Does a person have to respond to an inquiry by the police as to whether or not I have a license? Phillips, the author of the open carry. I don't believe so. If they don't have a legitimate reason to stop them, they have to have. And this is specifically talking about open carry. So he's not saying, well, yes, he's open carrying, therefore he's breaking the law. Ladies and gentlemen, these are the people that write the laws. Okay? These are the people that write the laws. So, and then he goes on. So with that amendment was so important because the amendment related to the word solely. They're solely carrying a firearm, right? They're not breaking any other laws. And by the way, filming is not breaking the law either. So even if they're just carrying a gun, or even if they're, but keep in mind, let's go back to this one more time. He's talking about the authority to disarm. If somebody is openly carrying, someone who is carrying a handgun openly or concealed, this is that word solely, because Salvaggio here isn't saying if they're filming and carrying a gun, here's what you can do. He is specifically saying only for the purpose of identifying someone who is carrying a handgun concealed or openly. Absent anything else. That is specifically what the House, when they were talking about the Dutton Amendment, was talking about when they decided, you know what, we're going to go ahead and we're going to drop this amendment because it's not needed. Okay? Because it's not needed. But we would like these comments reduced to writing. So that's what they did. The legislature put this in writing. Dutton says, I want citizens to be able to understand the point you just made. That because that is my fear in offering the amendment, that somehow or another, police officers may not apply this equally to everybody. And given the outcry from many police officers, but some of the things I've read that they've said creates a grave concern in my mind as to whether or not some will be treated differently than others. Isn't that exactly what Salvaggio is talking about here? He's talking about treating people differently, demanding that they show their license, stuff like that. Okay? Now, that's the House. So what about in the Senate? Did the Senate have anything to say about this? Because this right down here says, Rinaldi asked that these remarks between Dutton and Phillips be put into print. Why? This is what's called legislative intent. This is legislative intent. The legislature wanted law enforcement and the courts to realize just because we're not passing this amendment doesn't give you the right to stop and ID people just for open carrying. And they wanted to make sure it was put in writing so that they could go back and reference this. The cops, in other words, shouldn't need a law to specifically tell them what they can't do when the courts have already said what they can't do. And I've already covered that again in my blog post here on a soldier's perspective called An Open Letter to Texas Leos. If you want to see some of the case law, it's down there. But the Senate also had this debate, because what happened was the Huffines-Dutton Amendment was added to the open carry bills on each bill. The problem was it was worded slightly different. And I can't remember if it was the House or the Senate, which one was which. But in one version, there was language that said a firearm in the possession of a person. And in the other bill, in the House or Senate side, it said in a person's possession. Now, you and I, because we're normal people, that means the exact same thing. But to the legislature, in the possession of a person and a person's possession means two different things. So they had to go to what's called a conference committee. And that's why they had to debate this amendment, because the amendment itself was different in both chambers. And instead of fight the whole thing and go through and re-battle out to get open carry passed, both chambers just decided to drop the amendment since all the other language was identical. That way we were able to get open carry. So the Senate discussed this as well. Senator Taylor asked Senator Estes, who was the HB 910 co-sponsor up in the Senate. He said, I wanted to get some clarification about what was going on with this bill, the amendment. So Senator Taylor says, clearly, with the amendment gone, I just want to establish some legislative intent here. Law enforcement, are you listening? Salvaggio, are you listening? This is the legislature telling you, in passing this law, this is what we intend to do. All right? As we discussed, there are three kinds of meetings that can take place between an officer and a citizen: a voluntary encounter, a temporary detention, or an arrest. A voluntary encounter is a cop comes up to you, you're not doing anything wrong, and they just want to ask you questions or just talk to you or ask for directions or something like that. A temporary detention is they have a reasonable suspicion that you might be involved in a crime. For example, someone calls the police and says, someone broke into my house. I saw them running away. They were wearing a red t-shirt and blue shorts. Police officers are driving down the road 3 or 4 blocks away. They see you walking down the road with a red t-shirt and blue shorts. You meet the description of someone who may have committed a crime. That is a temporary detention because they have reasonable suspicion that you may be the person that broke into this house. All right? So they can do a temporary detention to determine if you are indeed the person that committed that crime, because you do match that description. And then they have what's called an arrest. An arrest means that they have probable cause. There's evidence to believe that you did commit a crime, more than just reasonable suspicion. That's the three. All right, those are the three there. So if they don't have reasonable suspicion that you've committed a crime, if they don't have probable cause that you've committed a crime, everything else is a voluntary encounter. That's what we're talking about here. Open carry, which is legal in Texas with a license. It's legal, so it's not probable cause, and it's not reasonable suspicion. So they talk a little bit, they go through this and all of that. And he says, okay. So Taylor says, with the bill as it is, in other words, without the amendment that we're debating here, with the bill as it is, a police officer may not detain a citizen, cannot stop them to determine if they have a concealed handgun license, merely because they are open carrying. Senator Estes, the bill's author, that's my understanding of constitutional law and settled law. Okay, Senator Taylor continues, and he's talking again about the difference between a voluntary encounter and an arrest. The other side of that coin, a peace officer may walk up to an individual who's carrying openly and ask them the time of day, what they had for dinner, where they live, if they have a CHL, how long they've had a CHL. But in no way does this bill stop a police officer from conducting a voluntary encounter with a citizen. That's correct. This was then asked to be filed and reduced to writing so that law enforcement can figure that out. All right? These are the people that passed the law. They talked about concealed and open carry. Just because you were concealed carrying, just because you were open carrying, law enforcement does not have the authority to stop you. All right? They just don't. Let's go back to this email. So we talked about this. Now, a little bit later that day, Chief Salvaggio sends out another email. Remember, the other one was at 7:30. This one here, let me get my marker on here. This one here is at 8:26. So about an hour later, Chief Salvaggio sends out another email with suggested dialogue on responding to a call from an alarmed citizen. So this is an armed citizen, nothing else. Someone walking down the road, enjoying a burger, filling up their gas tank, walking the dog, whatever, if they're carrying a firearm. So here's what, person carry to the person carrying the firearm. Stop right there. If the person carrying the firearm says, stop right there, don't come any closer to me, officer. I know the Constitution, the law, my rights. You have no legal authority to approach me. I will not voluntarily engage in any type of... In other words, what Chief is saying here is, hey, officers, let me tell you something. If one of those people that they believe that they know their rights because they know their rights a little better than we do, if they come up to you and they're not breaking the law, right, and they tell you, hey, I'm invoking my rights, leave me alone, I'm not breaking any law, I don't want a consensual encounter, all right, officers, this is what I want you to tell them, okay? Those liberty people, they can't have their rights. I know Salvaggio is nowhere near a Southern person, but that did sound like a retarded guy, and I wanted to use that voice because that's basically what I think Salvaggio sounds like. So here's what the officer is supposed to say. If you invoke your rights, keep this in mind, think about this. If you invoke your rights to be free of illegal search and seizure, right? This is what Salvaggio thinks the officer should, this is how he should respond. My name is Officer Insert Thug of the Leon Valley Police Department. I'm here in response to calls from alarmed citizens regarding your conduct. Regarding your conduct, carrying a firearm lawfully in Texas in a holster, or even, well, and he's only talking about handguns here because in his earlier email, I guess I didn't really bring this up. I didn't highlight this so much. He does talk about in this email here that we're only talking about handguns, not rifle. Here it is. Do not confuse the rights of open carry rifle or shotgun. He's only talking about handguns. I'm here in response to calls from alarmed citizens regarding your conduct. Now, he uses that word alarmed because 4201 of the Penal Code, which is disorderly conduct, section A8, says that it is disorderly conduct if you carry a firearm in a manner calculated to cause alarm. So he's intentionally using this word alarmed right here. All right. So the officer must continue. This is not a voluntary encounter. You are not free to leave. You have been legally approached, stopped, and detained for investigation into possible violations of the Texas Penal Code. And from this moment forward, your actions will be in compliance with the directives I will issue you. Please keep your hands away from your gun, or you will be disarmed. If you do not cooperate, you may be restrained for my safety and yours if necessary. Okay, if you're going to take my gun, it's not for my safety. I have no desire to shoot myself. Most people don't. Both of these are in accordance with state law. No, they are not. Nowhere in state law. Oh, I'll go back to Salvaggio's email here. Nowhere in state law does it say that. It says demands. 3802, and this was on my blog. Let me go back to 3802. We talked about this just briefly. You have to be lawfully arrested in order to demand a license to carry. So, continuing on. Do you understand everything I have said to you to this point? Once acknowledged, you should add this. As per state law, please provide your driver's license and license to carry a firearm. State law does not say that you are required to provide a state driver's license or license to carry a firearm just because a police officer demands it from you. It doesn't say that. Yes, they can demand your driver's license. They cannot. Nowhere in 205 here does it say they can demand your license to carry. It says that if he demands identification, that's the key word right there, identification. They have to demand that. Once they demand identification, if they can demand it, what is the difference between the three? You've got a voluntary, a temporary detention, and an arrest. To make a demand, there has to be a detention or an arrest. And by the way, you can't even make a demand if you're being detained. State law 3802 says that if you're being detained, you just can't lie about who you are. It still doesn't say you're required to present identification. Only if lawfully arrested. We've got that right here. Lawfully arrested the person. The law goes on later to say that if you are detained, you can't lie. It's a crime to lie about who you are if you're detained. Going back to this robotic script. So, as per state law, please provide, this is a request, please provide your driver's license. If they refuse, reference the last email concerning lawful detention. So this is your script. But look at this. There is no argument or discussion to be had. Chief Salvaggio thinks that their word is the final word. They think that they are the moral superiority. All legally carrying citizens receive this training when they take the... What? All legally carrying citizens receive this very training when they take the class to receive their license to carry and should comply. No. If you're getting this kind of training, you need to go get your money back because your instructor lied to you. If the person refuses to immediately comply, take the actions you have just advised them you would do if you believe it is necessary, which is to disarm them. That's what they want to do. Folks, we have a problem here in Leon Valley. They need to be educated. I have stayed out of Leon Valley for the most part. I mean, I've been critical of what Chief has been doing because I disagree with him violating anyone's rights. So that includes the First Amendment. But Open Carry Texas and I have not gotten involved on a gun level because there haven't been any gun issues. Well, now we have a gun issue. It's in his own handwriting. This is his email right there that he will demand, and you are apparently supposed to comply if you are openly carrying a firearm. That's no good. That's not going to fly. I'm not going to let it fly. And we will challenge Chief Salvaggio on what he believes his cops can do. I've just created or provided all of the evidence that Chief Salvaggio is wrong. I've provided the law under Texas law, which actually he's provided it as well. I have provided the case law, which undermines his entire argument. And I have provided the actual words of the people who wrote, voted on, and passed the law. If you think you know better than the people who wrote the law, what the law is, you've got a bigger head than even I thought you did, Chief Salvaggio. So I'm telling you right now, we will be party to any lawsuits in the future because I'm going to send you this video so that you are aware of what your limitations are, so that you can send out another email. And should there be any problems in the future, then we will go towards what is basically called when you use your authority under color of law. All right? Official oppression, ring any bells? We don't want to have to go that route. Do the right thing. Send out another email clarifying that law enforcement cannot stop and identify people solely for the act of open carry. You have to have probable cause to stop and identify somebody. Period. Point blank. End of story. And unless you want an Almost Park style protest and rally, you might want to fix this.